Well, it really is true. The guy who represents himself has a fool for a client. Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. And today we have an interesting case, this time again out of the Florida Supreme Court. And it involves a little politics, but the interesting part of this case isn't the politics so much as the procedure. So many of you may know that in August of 2022, Ron DeSantis suspended the state's attorney in the 13th Judicial District, which is the Tampa, Hillsborough County area. And as a result of that suspension, the state's attorney, the gentleman who had been suspended, went to federal court to get relief on a state law claim. And as a result of that, the federal court dismissed his actions. But before it did, it made a lot of statements that cast him in an approving light, which is really kind of odd when you get right down to it. And I think the opinion that we're going to go through here today sort of highlights that pretty well. But the bottom line in all of this is that the case eventually wound up 6 months later at the Florida Supreme Court, and the Florida Supreme Court was not having any of it. Let's take a look at the opinion from the Florida Supreme Court, and then I'll have a few comments after that. So this is the opinion of the Supreme Court in Andrew Warren versus Ron DeSantis. So on August 4th, 2022, the governor suspended Andrew Warren, who was the state's attorney for the 13th Judicial Circuit, on the grounds of neglect of duty and incompetence, arguing that the policies that he had instituted indicated that he was neglectful of duty and incompetent. More than 6 months later, petitioner filed a petition in this court arguing that the governor lacked authority to issue the executive order and requesting the issuance of a writ of quo warranto. And that writ would have directed the governor to reinstate him. And in the event that the court wasn't interested in doing that, Mr. Warren says, well, then in that case, just give me a writ of mandamus commanding the governor to reinstate me. After the filing of the petition, our court sought briefing from the parties, which concluded on May 4th. We agree with the governor that the petition should be denied on the ground of unreasonable delay. So then the court goes into the history here. Within 2 weeks of his suspension, the petitioner filed suit in federal district court seeking, among other things, a writ of quo warranto on the ground that the suspension order was facially insufficient under Florida law. So that's clearly a state law claim. The federal court dismissed the state law claim after concluding that the 11th Amendment to the Constitution barred that claim from being brought in federal court. And they quote the Pennhurst State School and Hospital versus Haldeman as just one of the cases that sets forth that rule. So then, petitioner waited almost 5 months before finally petitioning this court and requesting our expeditious review of his state law claim. The petitioner offers no explanation for the delay. We conclude under the circumstances that he basically lost his time to have us review the case, the Supreme Court review the case. Article 4, Section 7 of the Florida Constitution grants the governor the power to suspend from office any state officer not subject to impeachment, and enumerates the grounds for suspension, including neglect of duty and incompetence. That little part about what the Constitution requires, that's going to become important here in just a minute or two. A suspension is done by executive order, and then the Senate gets to weigh in, and if they agree, then the guy stays removed, and if they disagree, they can reinstate the suspended official. Although the text of Article 4, Section 7 does not attribute any role to the courts in the suspension matters, the court's precedents recognize a narrow role in the review of the suspension order. And they basically look at it to see if it satisfies the constitutional requirement of stating the grounds of the officer's suspension. That's a limited role that entails no more than determining whether the executive order on its face sets forth allegations of fact relating to one of the constitutionally enumerated grounds of suspension. So it only has to bear some reasonable relation, and some reasonable relation is a low threshold to satisfy, and he just needs to satisfy it on the whole. Indeed, we've previously said that the courts are not a check upon any erroneous action on the part of the governor or a mere error in judgment, whether that's free from or attended by some improper motive. Our Constitution instead has made the Senate the sole check upon any erroneous action by the governor. So what's interesting here is that's very clearly set out in the Constitution, and one would expect that a state's attorney, who obviously has to know the state's constitution, would know and understand that. One would expect that he would go and get good legal advice and, if necessary, bring his action in the Senate, but that isn't what happened. And they say, again, it's the function of the Senate, never that of the courts, to review the evidence upon which a governor suspends an officer. So the executive order suspending the petitioner cites the factual basis for the suspension as 2 joint statements signed by the petitioner and other elected prosecutors, as well as 2 presumptive non-enforcement policies purportedly instituted by the petitioner. Now, Andrew Warren got support from the Open Society Foundation, and I suspect that's at the heart of these 2 joint statements. The first joint statement had to do with gender-affirming health care, and the second had to do with abortion. And basically what he said is that he is not going to prosecute anything that deals with those 2 areas. Now, I take no position on whether or not you should just categorically not prosecute people if there are valid laws on the books regarding gender-affirming health care and abortion. I think that, personally I'm pro-life, but again, that is the function of the legislature to pass those laws. It's probably not the function of the prosecuting attorney to decide he's going to just ignore them. Regarding the petitioner's 2 policies, the executive order first describes the policy of presumptive non-enforcement of certain criminal violations, including trespassing at a business location, disorderly conduct, disorderly intoxication, and prostitution. If you got trespassed at a business, Andrew Warren would not prosecute you for that. If you engaged in disorderly conduct, he wouldn't prosecute that. And the second policy they had was against prosecuting crimes where the initial encounter between law enforcement and the defendant results from a non-criminal violation in connection with riding a bicycle or a pedestrian violation, and it includes the crimes of misdemeanor resisting arrest without violence, for example, fleeing from a law enforcement officer. As you might imagine, the Florida Sheriff's Association is not real fond of those policies and wants to protect their officers from essentially having their judgments in the field overruled by a state's attorney on a blanket basis. And I point that out because the Florida Sheriff's Association filed an amicus brief with the Florida Supreme Court in this case. And I found that to be somewhat interesting that they would file a brief here. But the governor, when he announced this, he had the support of pretty much every sheriff in that 13th Judicial District, which again is fairly important, I think, when you're evaluating whether or not he acted rashly or politically. He's clearly reacting, at least my belief is, he's clearly reacting to the pressure that's being applied by the law enforcement community about, why do we have these policies? So after addressing the joint statements, the executive order concludes the petitioner's avowed refusal to enforce certain criminal laws on a non-individualized, category-wide basis is a neglect of duty and a violation of his oath of office. And the order explains that neglect of duty is not excused by prosecutorial discretion because his blanket policies ensure he will exercise no discretion at all in entire categories of criminal cases. Public proclamations of non-enforcement further demonstrate his incompetence and lack of judgment arising from his gross ignorance of his official duties. Now that seems like a pretty stern and maybe over-the-top statement about gross ignorance, but when you consider how this case has unfolded, there may indeed be a little gross ignorance there. I'll leave that to you to decide. Because petitioner's unreasonable delay ultimately forms the basis for our decision to deny his petition, we review the more than 6 months gap between his suspension and the filing of the petition, and we briefly examine the federal district court proceedings which constitute the backdrop for petitioner's dilatory conduct and on which petitioner primarily relies in attacking the suspension. So get ready. This is a fairly rare occurrence, and I'm actually kind of glad to see it because nobody ever takes a swipe at the federal courts, mostly because people are generally afraid of federal court judges. But God bless the Florida Supreme Court because they're gonna throw some shade on the Florida District Court. So on August 17th, only 13 days after his suspension, he files this case in the Florida federal court, and he raised 2 claims. The first one was a violation of the First Amendment, specifically that the joint statements were protected speech, and suspending him because he filed these joint statements was retaliation for First Amendment conduct. Claim 2 sought a writ of quo warranto under Florida state law and alleged that the basis for suspension did not reasonably relate to either incompetence or neglect of duty and were thus facially insufficient. On September 29th, the federal court entered an order that in relevant part dismissed without prejudice petitioner's state law claim and allowed only the First Amendment claim to proceed. The federal district court unsurprisingly dismissed on the basis of the 11th Amendment. 4 months later, in January of 2023, the federal district court entered an order that dismissed on the merits with prejudice petitioner's First Amendment claim and said, look, ultimately, the governor would have suspended petitioner based solely on factors that are not protected by the First Amendment, and as a result, the petitioner is not entitled to that relief under the First Amendment. Inexplicably, despite having previously dismissed petitioner's state law claim, a claim that challenged the facial sufficiency of the suspension order, the federal district court proceeded to reach various conclusions regarding the propriety of the suspension under Florida law. Indeed, the federal district court twice stated that the suspension violated the Florida Constitution. Now, the reason that's important is because the Florida Constitution says the courts have no role. So, obviously, the only person or the only entity that can overturn this suspension is the Senate. And for whatever reason, Andrew Warren didn't go there. But the court found that it violated the Florida Constitution, which is absolutely incorrect. And the Florida Supreme Court is firing a shot across his bow, basically telling him, hey, you goofed up here. And the federal district court purported to decide certain factual issues, including whether Mr. Warren neglected his duty or was incompetent. But, as the court points out, it's the function of the Florida Senate and never that of the courts to review the evidence upon which a governor suspends an officer. At one point, the federal district court challenged the governor to simply rescind the suspension and then seemingly questioned the ability of the Florida Senate to dutifully carry out its constitutional role, referring to that legislative body as heavily partisan. Almost 1 month after the federal district court issued its merits order, extraneous comments and all, and more than 6 months after his suspension, petitioner finally knocked on this court's door and requested our expeditious review. Petitioner's primary arguments rely on the principle of collateral estoppel, or issue preclusion. Now, I just recently did a video on collateral estoppel and issue preclusion, but let's review real quickly what you have to have issue preclusion or collateral estoppel. So the first thing you have to have is a valid final judgment that binds both parties. And the same issues have to have been actually litigated in that judgment. And if that didn't happen, then you don't have collateral estoppel. About 5 minutes just on Google would have told Andrew Warren that he could not claim collateral estoppel when not only had he lost in federal court, but he himself had petitioned for an appeal. But Warren argues that the factual findings are preclusive and must be given effect. Petitioner's alternative petition for a writ of mandamus relies almost entirely on the district court's judgment. Quite questionably, petitioner presents his collateral estoppel arguments even though the federal district court dismissed all of his claims. And petitioner presents these arguments even though the federal district court's order on the merits is currently the subject of an appeal by petitioner himself. So that's pretty interesting. Issue preclusion is a plea available to prevailing parties. Issue preclusion, in short, does not transform final judgment losers into civil or criminal proceedings into partially prevailing parties. And that's absolutely true. That's federal law as well as state law. Under Article 5, Section 3B8 of the Florida Constitution, this court can issue a writ of quo warranto, and they go into that. Although quo warranto is an extraordinary writ, it's potentially available in various circumstances, but it's within the discretion of the court, meaning the court doesn't have to grant the writ even if it thinks the person might be entitled to relief. The nature of an extraordinary writ is not of absolute right. In other words, you don't have any right to have an extraordinary writ issue on your behalf. Given the nature of the writ, there may be circumstances in which a court denies relief for reasons other than the actual merits, and that's what's going to happen here. Within 2 weeks of his suspension, petitioner sought the writ in federal court. He brought that claim in a federal district court, a court that petitioner should have known was wholly without jurisdiction to consider the claim. Indeed, just a few weeks later, that court informed petitioner that his claim was barred in federal court and any relief would have to be sought in state court. Petitioner, who was ready to challenge the facial sufficiency of the order within 2 weeks of his suspension, then waited almost 5 more months before bringing that claim in state court, all but ensuring that the 2023 regular session of the Florida Senate would come and go without any opportunity for that legislative body to potentially review the suspension. So he cites significant public interest and all that as a reason why they should issue the writ, but the court says his unreasonable delay does not necessarily leave him without any potential remedy. The Senate is nothing less than a court provided to examine into determine whether or not the governor's power of suspension is keeping with the constitutional mandate. So as a result, the petition is denied. So here's what I think about this case. First of all, I think that anybody who had been to law school would know that a court has to have subject matter jurisdiction. Subject matter jurisdiction in federal court is of 2 varieties: diversity jurisdiction and federal question jurisdiction. Now, arguably, his First Amendment claim may have had federal jurisdictional tethers, and he could have brought those claims, except for the fact that you cannot bring a claim for violation of the First Amendment against the state. It's barred very clearly by the 11th Amendment to the Constitution. And again, a lawyer who had graduated from law school would know that. More importantly, the claim that you want a writ of quo warranto based on state law to reinstate the state's attorney, well, there has to be diversity of jurisdiction for a state law claim to have any tether. Now, again, ordinarily, you can have a state law claim joined with a federal law claim. That happens a lot in civil cases. But the problem is only if the federal claim is jurisdictionally okay. And clearly it wasn't, because it's barred by the 11th Amendment. Now, because he doesn't have diversity of jurisdiction, if Andrew Warren had sued the governor of Alabama, he would have had diversity jurisdiction. But since he's in Tampa and the governor's in Tallahassee, they're in the same state, he does not have diversity jurisdiction. So he can't sue in federal court in the manner that he did, unless he sticks with a constitutional claim, a First Amendment claim, and only then if it's not barred by the 11th Amendment, and it clearly was. So it's really curious to me that he would come into federal court in the first instance, and then, having lost in the federal court, assert as a basis for the court to issue a writ that he is somehow entitled to collateral estoppel. Collateral estoppel just doesn't work that way. If the judge makes findings that, you're entitled to millions of dollars and then dismisses your case, it has no collateral estoppel effects because it's not a judgment that essentially you won on. Again, I don't understand who was advising Andrew Warren in filing this, but clearly they did not understand exactly what they were doing. Now, a little inside baseball, I think, with regard to why the Florida Supreme Court denied this on the basis of delay. The major reason that they did that is because it looks like the delay from January through May in filing this case, was to allow the Senate to go out of session. And since the Senate is not in session and he wants to be reinstated immediately, he waits until they're out of session to file with the Florida Supreme Court. And the Florida Supreme Court saw right through that and basically said, no, sorry, you sat on your hands, you sat on your remedy. Even if we could review this, which we can't, because the only thing we can do is look to see if the suspension order is in proper form, and clearly it was. You waited 5 months, and the Senate's out of, and the one place that you can go to get relief is not available to you now. So, sorry, Charlie, you lose. Again, I think it's a good opinion by the Florida Supreme Court in that it balanced the need to get an answer out there quickly with the idea that you can't game the system. Now, one reason why this is very important now is because Governor DeSantis has suspended yet a second state's attorney. So it looks like we may go through this a second time with Ms. Worrell. And again, this is sort of a sad thing, to be elected to an office and then be removed. I'm sure that's quite a blow to the young lady who was the prosecutor. And I'm not unsympathetic to that. I know people want to address issues in their community, and they think that going easy on criminals is a solution. 68 years of experience in the world tells me that it isn't, but sometimes it is good to try new things. If you have any questions, please feel free to leave them in the comments down below. Now let's take a moment to think about kindness. One of the things that you can do that would be a kind act that would go on for generations is to plant a tree. Plant a tree at a city park. Plant a tree in your neighborhood. If you live in a gated community or an HOA, get permission from the HOA to plant a tree somewhere in the common area. Maybe dedicate it to someone or something. Anytime that you go to the trouble to plant a tree, you're putting something out there that's going to last a long time, and it's going to suck up carbon dioxide and spit out oxygen. So that's that is a good thing to do. It benefits society, and it's a kindness that you can do in many cases without ever even leaving home. So thanks for watching. Have a terrific day, and catch me down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.